Hi, I'm Bill Tierney with Sotheby's here in Cohasset, and I'm with my favorite top attorney, somebody I've worked with for 6, 7, 8 years now, Mark Stiles.
Hi, thank you for having me, Bill.
And today we're going to cover just a couple of tips of what's going on with the real estate transaction, and hopefully it makes your understanding of the process just a little bit better.
Awesome, looking forward to it.
Sounds good. Let's get started. So, Mark, here's a question I get all the time. When I work with buyers, they're coming in to Massachusetts from other states.
Yep.
And they've purchased out of state, they've purchased in California
Yep.
or elsewhere. And I introduce their need for an attorney.
Why do we need an attorney?
Exactly. Get that all the time.
We get it all the time, too. So in a lot of states, California, Florida, they're called title states, non-attorney states. Massachusetts is considered an attorney state. But in the purchase and sale agreement process, technically you don't need an attorney. It's highly recommended because our document in Massachusetts is negotiated very heavily. As opposed to in California and Florida, you have a standard document that really isn't negotiated other than price and date. Everything else is been pre-negotiated, and it's just the way it is, kind of like when we were dealing with bank-owned properties.
Okay.
You're not allowed to negotiate this. This is the document. If you want to agree to it, sign it. Otherwise, move on. We're going to the next guy. So that's the reason why you would want in a purchase and sale agreement, because we're doing a lot more modifications and negotiating with the buyers and the sellers in Massachusetts.
But doesn't the lender get involved here and want some input?
The lender does, and the lender's going to have their own attorney. Oftentimes in Massachusetts, you'll find the lender's attorney is the same as the buyer's attorney. If you're working with a team, it makes sense. A lot of the work is the same.
Yep.
But the buyer has separate, distinct interests where the lender doesn't. So at a certain point in time, the buyer and the lender align completely and run parallel tracks. They want to have title. They want to have a clear title. They want to have the documents properly recorded. They want to have all the names and all the finances and all of that correct. But prior to that, when you're negotiating a purchase and sale agreement, which is a really important document, and it's got certain timelines in there that need to be adhered to, that person needs to be represented separately. Sometimes it's a different person than what the lender has, but by statute, the lender has to have an attorney at the closing handling it.
So the offer then is more like a memorandum of understanding, and the P&S is an expanded version of that?
That's correct. If you remember on our last video when we talked about the offer, it is a contract, but it is kind of like a memorandum of understanding because it's 1, maybe 2 pages long. It has 4 to 5 terms into it, where a purchase and sale agreement is typically between 5 and 8 pages long, sometimes 16. Not documents that we're used to dealing with, but bank-owned. Sometimes they're 16 pages long, and they incorporate a lot more disclosures. The sellers disclosing certain items that the buyer is requesting that they disclose to them. It speaks to default remedies. So if the buyer decides that they can't buy the property, what happens? Or the seller gets cold feet and says, we don't want to sell anymore. Well, what happens in that situation? So it memorializes more of the terms that the offer first started with and battens down the hatches, in essence.
Okay. So, that sounds like there's a little bit more to it.
Yeah. And we get everybody's on track to the closing, so everybody knows what their responsibilities are, who has which responsibility, including the agents. Those would be listed in the purchase and sale agreement as well, and everybody knows what their responsibilities are to get to a smooth closing.
And this gets back to what I constantly talk about at the end of all these videos, the team approach, being able to work with an attorney who's focused on getting the closing done, be able to work with a lender who's going to have their own input, so to speak, on the P&S, and keeping your eyes on the prize of getting buyer and seller together.
Bring them together and get them to closing. That's what they want, right? Buyer wouldn't be in this situation buying the property if they didn't want to buy it, and the seller certainly wouldn't be selling the property if they didn't want to sell it. So let's not get in the way, and let's get them to the closing.
That's the point of the goal. Hey, thank you so much for giving me a couple minutes to watch this video. Mark, I appreciate
Hey, Bill,
your time.
thanks for having me.
Awesome. This is fun. Thank you, guys. We'll talk soon.